Number 78 on the calendar, People against Baasil Reynolds.
Good afternoon, Your Honors. Michael Woodruff for Mr. Baasil Reynolds. I respectfully request 2 minutes. Your Honors, this Court should vacate Baasil Reynolds' plea because the trial court imposed an illegal pre-sentencing condition when it required Mr. Reynolds to serve a hard year imprisonment before he was sentenced.
Was it an illegal sentencing condition, or was it an illegal sentence?
Illegal sentencing condition, pre-sentencing condition.
I see.
Okay. Imprisonment is only authorized as a sentence, and this Court has held that pre-sentencing conditions cannot violate statute and they cannot contravene public policy. And here in this case, the arrangement that was made did both of those things. And the case I'm referring to there is People v. Avery, where the Court laid that rule. And the way it violated statute is that the governing mechanism that dealt with this procedural move, adjourning the case for 6 months, an additional 6 months, because Mr. Reynolds had already served 6 months to constitute a hard year. The criminal procedure law, section 410, subsection 4, is what gave the court the authority to do this, to adjourn.
Does your argument require preservation?
Preservation is not required in this case.
Are you familiar with our recent decision in People v. Williams?
I am, Your Honor.
Okay,
and that's a different class of cases. This Court has explicitly held that in this case, this type of case.
This type of case meaning an illegal
pre-sentencing condition, yeah. And the case that I'm referring to is People v. Avery. And there, this Court explicitly held that the appellate division erroneously held that a challenge of a trial court's authority to unlawfully condition and defer sentencing was unpreserved. And then this Court cited People v. Rodney E. And People v. Rodney E. is the controlling case. And
did Rodney E. talk about preservation?
It didn't, Your Honor. And I don't think the Court thought it was an issue because of the nature of the claim that was being made. And I believe that this is a separate issue than People v. Williams because it's very distinguishable for a number of reasons. I think most importantly, People v. Williams involved the voluntariness of the plea. Also, another major factor is that in that case, what the judge had told the defendant, Williams, was that you're going to receive a sentence of 3 years. And that was unlawful. The judge didn't have his sentencing guidelines with him. But he never received anything unlawful there.
Getting back to Rodney and Avery, though, in those cases, wasn't what was violated the exact pre-sentence condition that was at issue?
Well, here there's no way for Mr. Reynolds to violate the first condition. There were 2 conditions that he had to satisfy. The first one was 6 months of incarceration. There's no way he could violate that.
Well, would he have violated it if he had made a bail application? Would that be a violation?
He could have made the bail application, but the judge would never have granted it because he had agreed to do an additional 6 months.
You say an additional 6 months. I kind of lost track of this. When he was arrested, was he incarcerated pending trial for
That's correct, Your Honor.
6 months? That's
correct.
So then the judge says, well, you're already in for 6. If you do another 6,
yes,
then you can do this deal.
Well,
then we'll let you out.
Well, the arrangement was they were scheduled for trial 6 months in. They answered ready. Here's the offer. Do an additional 6 months to constitute a year, be released, adjourn the case for a year, have no new arrests for a year, and after that period of time, then you can take your plea back and get a misdemeanor.
Yeah. So wasn't the sentence, the year sentence, based upon the fact that of the charges that were pending?
I don't know what it was based on.
Because there had been they obviously didn't end, right?
Well, from the record, all that I can glean from that is that that's what the prosecutor's office felt was appropriate, and a hard year, and then stay out of trouble for another year, and then if you do that, then we think you've earned the misdemeanor.
But did he plead before? Did he plead before he went in for the second 6?
He pled at the 6-month point of being in custody, and so he entered the plea, And then the case was adjourned for sentencing. Sentencing didn't occur until 2 years after he was arrested and put in custody.
But he pled to a felony, right?
That's correct.
And at that point, the judge said, you've already been in 6. I'm putting you back for 6.
Mm-hmm.
And then I'm going to let you out, and if you're okay for a year, if you don't, then we'll kick it down to a misdemeanor.
Well, what I think is really important to focus on is the procedural mechanism that was done and what allowed for this. So that's 410 subsection 4. And it refers to and cross-references Penal Law 6510, which outlines a list of conditions that courts are allowed to impose. And those conditions are all rehabilitative in nature, and this court has analyzed those conditions in People versus Letterloff.
Are these the ACD conditions that you're talking about?
Well, no, these are just a list of conditions. They range from mental health treatment to substance abuse treatment to not having relationships with disreputable persons. But there's a
You're
catch-all.
talking about probation conditions or conditional discharge conditions? Is that what you're talking
Yeah,
about?
they are. Yeah,
Those are statutory conditions. The
That's
problem
correct.
I'm having here, though, is with, if you didn't like it, wouldn't you have to move to vacate the plea?
No, because preservation is just not a requirement.
It
in
wouldn't
this
be a
type of
requirement if it was an illegal sentence. I understand that.
Mm-hmm.
But this is a condition to a pre-sentence report almost. So
Well-
that's not the same. It's
Well,
not the
Your
same.
Honor, so
it'd be
it-
easy, I think, if this was an illegal sentence. It would be illegal, but that's not what we have here.
Well, this court held
The
in-
second part of that question, just to be fair to you, is that the people argue that any pre-sentencing detention isn't reviewable on appeal. I suppose you could have brought an interlocutory appeal before the sentencing, but after the sentencing has taken place, you can't challenge a pre-sentencing detention.
Well, that's not what happened here. This was explicitly explained as a pre-sentencing condition. It wasn't an adjournment.
But he has subsequently been sentenced, and the challenge is after the sentence. He got the 2 to 4 after the enhancement, which is a separate issue. But
Well, this was clearly a condition, and I believe that People versus Avery and People versus Letterloff control. And the reason why is this court held that a condition that the court imposed, that you put a convicted DWI sign on your plate, was not a condition that the trial court was authorized to impose because it wasn't enumerated in 6510-2. And it said it wasn't
I'm sorry. Go ahead. I want you to finish.
Well, there this court said, here's a condition that the legislature didn't think of, but it was punitive, and it wasn't rehabilitative. Incarceration cannot get more punitive. If this court felt a DWI conviction sign was contrary to 6510-2, I don't see how this court could see or reason that incarceration isn't punitive.
And based on that argument, you would say that defendant couldn't consent to a condition which would incarcerate him. So even if he wanted to stay in prison and do that extra 6 months, that would be illegal as well.
That's correct.
He couldn't consent to it.
That's correct. Well, and this arrangement, the way it was done was illegal. But there are other mechanisms available to have this type of flexibility, so you have to look at split sentences.
yeah, but it wasn't available for him. In fairness to the court, I think what the court was trying to do here is he was trying to give a man who committed a relatively minor crime, but because of his criminal history, he couldn't get misdemeanor time. He's trying to give somebody misdemeanor time who was stuck because of his criminal history with felony time.
Well, probation, the maximum sentence there on a felony, Class D, is 6 months. And that's, so they definitely could have done something similar
Well,
if it was
that wasn't
sentenced.
going to happen here. But he was trying to give him misdemeanor time. I think that was the real effort here. We can't really fault the court for the effort.
Your Honor, if I may, if he was trying to give a misdemeanor time, that contravenes good time credits, because if you're sentenced to a year on a misdemeanor with good time
The
credits,
people
you
were
only do
pushing
8.
for a hard year on this. That might have been the.
I agree, and they were, but it wasn't. It was the way it was done was unlawful. The law, the statutes didn't authorize it, and for those reasons, I believe this court should vacate Mr. Reynolds' plea. Thank you.
Thank you, counsel. Counsel?
Good afternoon. Vincent Revelisi for the People. I think the thing to remember first here is that the defendant pleaded guilty factually and legally to the felony, for which the minimum sentence was 2 to 4 years. the judge was very clear that this was the sentence that he would get unless he met the conditions. The conditions here were for the defendant's benefit to get a result that he would not have been able to get without the people's consent and the court's consent.
Well, maybe he wouldn't have pled to that felony if this whole deal hadn't been worked out, right?
True, he could have gone to trial. He wanted to get a better deal than the people were willing to consent to. If he had gone to trial, he'd have been rolling the dice on the felony.
Did he plead to what he was charged with?
He pleaded to the top charge, correct.
The top charge.
Yes. And so that the minimum was 2 to 4 because of his predicate status. The people and the court, I would say, bent over backwards to try to give him a chance to do better than that and to get the misdemeanor sentence. But the people were not willing to give him less than a year. So he pleaded guilty to the felony, for which 2 to 4 was the minimum, and he did a year of that before he was allowed to be released and see if he could do 1 year without getting in trouble.
Are you arguing that this is not reviewable on direct appeal?
Well, the actual securing order is not reviewable. That's correct.
Well, how the court said, the appellate division said, I believe it was the appellate division said that it would have had to be brought as a habeas corpus or something, right?
Right.
Well, how would that happen? Because he's not challenging the denial of or excessive bail.
Right. Well, I guess what it is that it's not an illegal thing to set the bail where it was, but if there were a problem with the bail and that he were remanded as opposed to being able to make bail, you would have to challenge that on a habeas proceeding. I mean, at this point now —
But that's not the challenge.
Well,
it's not about his ability to make bail. It's about this condition that was placed on him.
Right. But with all defendants that serve some time before they plead guilty, there's a certain amount of jail that's going to be credited against their sentences. And to be arguing now that, well, he did this year, his sentence is 2 to 4. It's not the 1 year. Right now it's 2 to 4. But I guess there's another component of preservation besides the securing order here, which is that he could have argued at any time before his appeal that what was promised to him was illegal, that he shouldn't have been able to accept this condition, because that's plain on the record. And that's, I think, what you were saying about the Williams case before. This is something he easily could have said was wrong with the deal and didn't say so.
But what about how do we get around Rodney and Avery?
Well, Rodney was the court ordering the probation department to take actions that there was no authority statutorily for them to take. And in Avery, the court explained that one of the reasons that Rodney held as it did was because the court was trying to impose probation when the probation department could not be ordered to do this. And I think in Avery what the court said was that Rodney E. was not intended to prevent the result of pre-sentence supervision if the court could arrange it, but just — I'm not quoting, by the way, this is a paraphrase — but that it had no statutory power to order the probation. It still has the power to oversee plea bargains tailored to individual circumstances. And in Avery, the court was doing a drug program. There was nothing that it had to order anybody to do outside of their statutory power, so that was permissible. And in Rodney E., the court was creating something that didn't exist, and that was not permissible. So the difference here is that nothing that the court did along the way was an illegal action. Everything that was agreed to here, the court had the power to do.
Wouldn't this open the door to getting around all sorts of sentencing requirements? Like, you know, if you agree to spend a certain period of time in jail, we won't, you know, we'll give you this charge, and then we won't give you post-release supervision or something like that?
Well, if you had pleaded guilty initially to the misdemeanor, but you wanted to give him more than the misdemeanor sentence or avoid good time, and so you said, you stay in jail and do a year, and then we'll actually formally impose the sentence, so that way you do a full year, that could be a problem. But if you're pleading guilty to a felony where you have to do 2 to 4, and the prosecutor and the court say, but we'll consent to give you a better deal and replead and get less, that's different, because you haven't done more than the sentence that's authorized for what you've actually admitted doing, what you're actually guilty of. You're just getting a break later. So it's really not an enhancement that took place here. It was the avoiding of, or it was the imposition of the actual sentence that he was trying to avoid. It would be different, perhaps, if he had pleaded guilty to something and got a longer term because
you
of...
You don't see that. It seems to me that there's an enormous range of statutes that you've gotten around. A guy's in jail for a year. There's been no trial. He's not been called ready. He's not meeting the probation standard. He's not meeting the conditional dismissal standard. There's a series of conditions that they have to meet. The judge has no statutory authority to do this. He's created his authority to do this. The people are going along with it, not out of bad desires. I don't think there's bad motives here or anything, but I can't find the authority for what you're claiming the court did here.
Well, the authority is that each step of the way, the actions that the court took were legal.
No, let me take a step back just on that second, then you can respond to it. we can't make up sentences. If you're pleading to a crime, I can't, as a judge, go in and say, yeah, but I don't like that sentence, so you're going to plead to this crime, but you get a different kind of sentence that I've concocted unless it's statutorily created. This is something that's outside the statutory construct. I think everyone would admit that. So I just don't see where the authority is for the court to do this.
It's actually not outside the statutory construct because he was pleading guilty to the felony and he was being promised 2 to 4 and offered a chance to have a better result. So the 2 to 4 was the promise.
The court can't give him less than 2 to 4.
Right.
By law, he's got to give him 2 to 4 if he pleads to that crime.
And what they were doing is giving him a chance to withdraw his plea, which he would have been allowed to do had he not violated, which is the separate point of the brief, but violated the condition, and then he'd have withdrawn the plea. And at that point, he would have served more time than he could have gotten on a misdemeanor. Yes, but less than the 2 to 4.
I see.
So if he had pleaded to the misdemeanor first, what you're saying would be exactly right, because then he'd be getting a longer sentence on agreement to do a year before he got sentenced. But because
kind of what I'm saying really is that the court is constrained whatever its desires to what the statute allows it to sentence somebody to. And here, this construct is outside of any statutorily imposed sentencing powers that the court has. So the question is, does it have an inherent discretionary authority to do that? Because you certainly couldn't set bail on him and leave him in jail for a year. They'd have to call readiness or a whole other series of things. So there had to be a plea. There was a plea. So we're post-plea now. I have never seen anything like this. At my end of the state. It may be more common down in the city. But.
Well, and it was certainly creative, and I think they realized that it was creative, and the judge called it unorthodox. But it was something everyone agreed to. It was something that was done for the benefit of the defendant. It didn't turn out because of the violation that it was to his benefit. And that was something that did not involve any specific illegal actions, and which makes it different from in Ray Rodney.
But you understand the principle. The principle is that in this instance, the court's trying to cut the defendant a break. But what if the court was going the other way and was making up sentencing guidelines that were, say, in this instance, I don't think I have to follow the statute. For personal reasons, I think that this crime deserves a different kind of sentence than it's outside the statutory construct, and I'm going to give it here, and I'm going to impose conditions that are outside of the statutory authorized conditions because I think in fairness to the victim, I'm going to do that. Couldn't do that, right? That would be self-evident.
Probably not, but then it would be preserved because the defendant wouldn't accept it, but, and so it probably wouldn't have happened. But in this case, I think everything that was done was agreed to, which, again, is a reason to require preservation.
So then we're down to can you agree to the illegal sentence, if it's an illegal sentence?
Well, and of course, again, I'd say it wasn't illegal only because he's getting 2 to 4. That's what the real sentence is. This was all just a chance to not get the 2 to 4.
Okay. Thank you.
Unless there are any other questions, I'll rest on the rest of the brief.
Thank you, counsel.
So, Your Honors, this is a question of criminal procedure law, and there's statutory law that explicitly governs this procedure, what took place here, and that's 410 subsection 4 specifically, but 410 is about pre-sentencing conferences. The purpose for that is for a judge, when imposing sentence, to glean more information about the defendant and what would be an appropriate sentence. And that's why subsection 4 then refers to 6510, because policy in the legislature has determined that we want rehabilitation to be an important component when a judge is evaluating what's an appropriate sentence. Have we addressed the underlying root cause of why somebody is in the criminal justice system to begin with? And that's why.
If everything had happened here the way it happened, only he wasn't put in jail, he was just released OR, would that be any problem, adjourning sentencing for a year?
Let me see if I understand. So incarceration was off the table?
Right.
That would be a completely separate issue. We that would be because it wouldn't be punitive. Right here, we're looking.
Well, it's not the procedure you're worried about. It's the fact that it's punitive as opposed to rehabilitative.
Well, it is the procedure, insofar as that 410-4 says that it can only pre-sentencing conditions can only be rehabilitative.
I guess I'm looking at it. You're right. It's pre-sentence. This isn't a sentence. He wasn't sentenced to a year.
That's correct. And it was a condition.
And he'd already done 6, and the judge said, I'm going to adjourn sentencing. Now, if he couldn't make bail, he'd be in jail for a year while they adjourn sentencing. Right?
So the condition was just stay out of trouble for...
No, just, I'm going to adjourn sentencing.
We could make the same argument that's being made today because no services were being provided that were rehabilitative in nature.
But are you entitled to rehabilitative services post-plea but pre-sentence?
That's what 6510 being referenced by 410 is for. It's for you to do a drug treatment program, and if you complete the drug treatment program, then you're entitled to the reduced sentence.
I see your light is on, but I do have a question that relates to a second point that you were arguing, the Outley hearing, about the arrest, or the arrest that, and you seem to be suggesting that conditioning this sentence on not getting into trouble, meaning not getting arrested, would be okay. Is that basically your point?
No, Your Honor. It's a very narrow issue, and it's a little difficult to thread. But the argument, very narrowly, is that the trial court didn't decide Outley correctly, or didn't apply Outley correctly, in that it confused the legitimate basis standard with probable cause. And so due process is in play here, and it's a spectrum on of how much process is due. Now, we're not challenging the amount, the form of the evidentiary hearing. All the evidence was there. What the problem is that the judge didn't decide the matter, that Mr. Reynolds was challenging the motivations of the complainant.
Well, so are you saying that at the Outley hearing, a determination had to be made as to the merit of his alleged defense?
Yes.
Isn't that exactly what we said isn't required?
No. Well, this Court has said that an enhanced sentence can only be imposed on a violation of a no-arrest condition when it's not malicious or baseless. There are no underlying
well, here there's a credibility determination.
Exactly.
Right? And so
exactly.
So it seems to me that the effect of what you're arguing is that the court, then the court has to make that credibility determination, which is deciding the merits.
It needed to decide who it believed was more credible, because it had the two individuals in the court.
The court did decide, which it seems to me happened here, that the complainant was more credible, and therefore that gave the police a sufficient basis to make an arrest. Well, does that take care of it? Is it just how it was articulated that you're concerned with, or
well, by reading the court's findings, it said it relied exclusively on the information available to the police officer, that the police officer made a valid arrest. But was it a legitimate arrest? And that's what Mr. Reynolds was challenging.
Right. You're saying she said, well, the cop had a good reason to arrest.
Yes.
And you're saying what she should have said is, if it was true, Mr. Glover, made sufficient allegations to support the arrest. I find Glover's testimony credible. I find Reynolds' testimony incredible. Therefore, this was a legitimate basis for this arrest. That's what should have happened. That's not what happened. And we have a cold record here. So we don't know what the determination would be there. So for the relief for that is to remit the matter for further factual findings.
Thank you,
Thank
counsel.
you.